So I'm going to move from the conceptual to sort of the application of what we've been talking about. In the beginning, really in the early 90s, as Professor Roche mentioned, there was a wave of state legislative responses to the concern about genetic privacy and discrimination. Those state actions were precipitated by a significant amount of anecdotal evidence. We didn't have particularly good statistical evidence, but a significant amount of anecdotal evidence that genetic discrimination was occurring, particularly in the health insurance and employment contexts. The two most prominent examples to give you sort of an understanding of how this was actually occurring were actually in the employment context. One was with Lawrence Berkeley Laboratory, and Lawrence Berkeley had been testing employee samples for a whole host of different conditions, including sickle cell, of their African American employees. But perhaps the most prominent was the case of Burlington Northern Railroad. In the case of Burlington Northern, what had happened was there had been a number of individuals, track workers in North Dakota, who worked on the tracks with heavy machinery, and they had filed a workers' compensation claim for carpal tunnel syndrome. The employer, Burlington, in its effort to find the case without merit, attempted to run additional genetic tests for predisposition to carpal tunnel syndrome. Now, the irony here was that there actually wasn't any scientifically authentic test at the time, nor is there now really, for carpal tunnel. But that was at least the attempt. And the idea being that they would designate the carpal tunnel syndrome as a pre-existing condition, thereby being able to not have to pay the workers' compensation claim. That was perhaps the most prominent example, but we were seeing examples in both the health insurance and in the employment context as well. We were also seeing from the early 90s rapid growth in the number of tests that could identify genes that correlated with particular diseases or conditions. And as the science was starting to progress, there was an outcry, particularly from the science and biotechnology community, that was concerned that people were not getting tested for themselves, that people weren't participating in clinical trials because they were afraid that there were not sufficient legal protections in place once they did so for their genetic information. So that was an additional factor. So in terms of GINA, the Genetic Information Non-Discrimination Act, which did pass in 2008, one of the most important things to understand is what exactly we mean by genetic information. Genetic information, at least as encapsulated in GINA, envisions three different areas. The results of a genetic test, the results of a genetic test of a family member, and perhaps most importantly, at least for now, family history. We've been talking so far a lot about genetic tests, but the truth is that today, and probably still for the foreseeable future, the main form of genetic information that we will see is still going to remain family history. So what isn't genetic information? Well, genetic information doesn't encapsulate a lot of the more common tests that you might see, sex or age, other routine tests, cholesterol and such. So what does GINA do? GINA consists of two titles, Title I, which covers health insurance, and Title II, which covers employment. Both titles have provisions that deal with privacy and the collection of genetic information, as well as the potential for corresponding discrimination. In Title I, in terms of discrimination, health insurers are prohibited from using genetic information in setting eligibility or premium, or in using genetic information as a pre-existing condition. They are also prohibited from collecting genetic information, both for an individual who might be applying for health insurance, as well as an individual who already has health insurance for any type of underwriting purposes. So, and there are no exceptions. This is an important distinction from Title II, where the exceptions, where there are several exceptions that are important. There are no exceptions for the collection of genetic information by health insurers. In terms of employment, GINA follows, in much of its language, follows much of the civil rights language that you'll see in any of the pre-existing civil rights laws, from the Americans with Disabilities Act to Title VII, ADEA, on forward. It prohibits discrimination based on any terms or conditions of employment. There are no exceptions in either title for in terms of discrimination. It also makes it an unlawful employment practice to request, require, or purchase the genetic information of an employee. And this is perhaps one of the most discussed areas of GINA, is the collection of genetic information, particularly because Title II has several important exceptions. And those exceptions, the most important exceptions are at the beginning of this list. In the inadvertent request exception, which is oftentimes called the water cooler exception, this is the type of scenario, for example, where an employer might approach an employee, ask how they're feeling, and the employee volunteers some information along the lines of my mother just came down with cancer, or I just had a positive BRCA1 test. It's a gene that's linked to breast and ovarian cancer. So there are those types of sort of open-ended, familiar questions that an employer might ask an employee, for which an employee divulges genetic information. That's an exception in terms of acquisition of genetic information. Health or genetic services, that's also a significant exception. That's most likely in the form of an employer-sponsored wellness program. Many employers have adopted or are in the process of adopting wellness programs. Many of them begin or sometimes consist solely of what's called a health risk assessment. A health risk assessment collects a whole host of information about the employee's health for purposes of tailoring or responding to that information in some way with beneficial information or programming. That is an exception, but I'll get into that a little bit more further. The genetic monitoring for toxic effects, that's for industries that process toxic chemicals for which there might be a reaction at the genetic level. That's it's an important but very restricted exception, and even that exception requires the voluntary consent of the employee. So even in a situation, the most often example that's given is chronic beryllium syndrome, which where in beryllium factories where employees who have a particular gene are much more susceptible to contracting the disease. Even under those conditions, the employee must consent to the testing. And some of them were, one of the other ones I'll note is the commercially and publicly available records. That exception specifically accepts medical databases. It specifically accepts court records, so those are not covered by the exception. And it's meant to address the type of situation, for example, where an employer might be reading the Sunday paper, comes across an obituary, or comes across some sort of an article or some sort of information. It's very similar in that way to the first exception, the inadvertent request exception. GINA also prohibits the disclosure of genetic information. It must be kept part of the employee's confidential medical record. In the same way, other medical information must be kept separate from the employee's personnel record. The exceptions to disclosure are relatively standard. The employee has to either request it, if it's done in a research capacity, but there are additional qualifications for that as well. GINA enforcement mirrors other civil rights laws in terms of Title II, the employment section. You have to file a complaint with the EEOC. If the EEOC finds merit, they'll give you a right to sue letter, and then you can pursue civil action with the limits on penalties that are available in other civil rights statutes. Title I, sorry. Under 15 employees are exempted. The same, right. So GINA GINA mirrors the federal civil rights laws, at least, in that respect. Title I, the health insurance section, does not have a private right of action, but it authorizes familiar agencies at the federal level or at the state level to pursue a claim. Relatively recently, the EEOC came down with final regulations that gave a lot more explanation to some of the language that we saw in Title II of GINA. And this final rule is particularly important in some areas that I will mention. In terms of definitions, genetic test, it expanded the definition of genetic test to more specifically include a whole host of types of tests that include genetic information. This is a bit common sense, but they want it to be comprehensive. So that includes newborn screening, as was mentioned earlier, ancestry testing, paternity testing, and others. It also, and this one is particularly important, clarified the definition of manifested disease. GINA covers and protects genetic information, but it does not protect individuals who may have manifested a disease, even if that disease is of genetic origin. So a person, for example, who develops breast cancer, even if that person is BRCA positive, the information about their breast cancer itself is not covered by GINA. But the final rule made sure to clarify that the underlying genetic information about the BRCA gene is covered by GINA, and it also went on to clarify exactly where the line is between genetic information and manifested disease, and if the genetic information is predominant, then even if there are perhaps some very minor symptoms that have already begun to show, and certain conditions do that very early on, then that is still covered information under GINA. In terms of privacy, and this is an important thing to note because this is different than certain other statutes, there is no specific intent required for the privacy protections in Title II of GINA. So you do not have to intentionally obtain genetic information to have a violation of GINA. So employers have to be particularly careful in that respect. In terms of the exceptions, and this is important to cover in a little more detail, with wellness programs, most wellness programs are voluntary in the sense that they're offered to the employee can choose to participate in the wellness program. But until GINA, the voluntary aspect of participation in a wellness program began and ended at the point that they chose to participate. Meaning that once they chose to participate and then would fill out a health risk assessment, as I mentioned earlier, those health risk assessments were required prior to GINA by employers traditionally in order to participate in the program. GINA makes a very important distinction to employer-sponsored wellness programs. What GINA says is that the voluntariness in terms of GINA follows the information. It doesn't follow participation in the program. So that an employee who chooses to participate in a wellness program must additionally choose to volunteer their genetic information as part of a health risk assessment or other part of the program that might seek to acquire that information. So that provision must be entirely voluntary. Additionally, if there are aspects of the employer wellness program that require you to meet a certain goal in order to qualify, those goals, there must be alternatives offered that do not require the employee to divulge genetic information if they choose not to. This is a large difference from the way wellness programs have generally operated until GINA, and so it remains to be seen exactly how well some of these programs accommodate themselves to these provisions.